Here we go. All right, go ahead, Jessica.
All right, everybody, thank you for joining us. And my name is Jessica Marcelino. I am the staff attorney here with the Center for Social Justice. And of course, Ariel Klemmer here is attorney extraordinaire and the director for the Center of Social Justice. We're glad that you're here to meet us tonight for this advanced training. So we're going to be going over things a little more in depth than what you may have learned in our basic training. So we're happy to have you. There's our contact information. I'm sure that you should have that already. And we're going to go through the way that we've structured this is the beginning. We're going to try to separate the time here with the first half or so in presenting information to you. And then we do have time scheduled to practice. So here's the agenda. A quick run through with the CDI and a small claims court session. I'm sure most of you are familiar. We'll talk about litigation strategies. So what are defenses? And also looking at documentation. So Ariel is going to take you step by step as to what a discovery packet may typically look like. And then ideally we want to break out into rooms and give everybody a chance to try to practice, make these arguments, get comfortable so that you'll feel better prepared and maybe shake off some of the jitters for if and when you volunteer and you're representing a defendant in court. You'll feel well prepared. That's the goal here. You'll be ready to go in front of the magistrate. Okay. So who are we? We have our next slide here, which is, there we go, lawyer for the day. So everybody, again, this is sort of just a refresher. You can sign up. We'll send this slide around after the training today, but there is a link to the sign up page if you haven't volunteered before. There's 2 sessions, one in the morning, one in the afternoon. As of right now, it's every Friday. Potentially there could be additional days during the week as well. And then sometimes there's follow-up. So oftentimes, depending on how many new clients we have, there may be some follow-up assignments, documents to be drafted. And we'll typically have a debriefing call where we go through and sort of assign what's next and steps to take moving forward. Okay. And so just a quick refresher, this is small claims court. Again, there is a link to the small claims rules here, of which there are only 10. Jurisdiction is $7,000 or below. A couple important things just to know, it's supposed to be the people's court, so it's rather informal. You don't have to file an answer as a defendant. Notice is sent just via regular mail. There's nothing certified. There's no sheriff that's serving this. And a complaint is called a statement of claim, sometimes referred to as a blue sheet. It's very basic. It limits, it outlines who's who, and then maybe we'll have a couple of sentences about the basis of the complaint and why that person is in court. Okay. And so there is a clerk magistrate. So at these hearings, if you haven't attended one before, you would see a magistrate. They're not a judge. They're typically a lawyer, though they don't have to be. You may notice if you've practiced in court before, rules of evidence are relaxed. There is some discovery. That's what we'll be going through with you today, but it's pretty informal. And that sort of, we can use that to our advantage in the arguments that we're making. And again, you don't have to be an attorney even to do this. In court, we will have a number of arguments outlined here. Some of them are sort of technical and others are more on fairness, moral grounds, that kind of thing. So if the plaintiff prevails, then there's a payment review hearing that is scheduled next. We have very limited scope of representation in those matters, so that's not a focus of today's training. It will be the first hearing. One thing to be aware of, something that we are required to do sort of in regular times, and of course in these COVID days, is a notice of limited appearance. So before everything was virtual, we would meet with folks in person and you could fill out documentation, hand it right to the clerk. It is necessary. It's a form it advises the court and opposing counsel that we are representing this particular client. We do have templates that we have drafted, and it has, there's either Ariel or mostly my information at this point. And what we do is we fill in the specific name of the client, and that would be submitted to the court. So again, pre-COVID days, you make a number of copies, you give it to the court, opposing counsel. Now we, as part of the center, we can e-file them online if it's a client that we are representing ahead of time, or if it's somebody that we've just picked up in the session, we have the same document that we can prepare, and then what we're doing is emailing it to the magistrate after the session. So again, that's something there would always be myself or another experienced volunteer assisting with that, but it's just important to understand that part of the process. So trial strategy and common defenses. There are a number that we are going to go through here today. Again, some of them are a little more technical, others are sort of more justice-based or fairness-based. We're going to talk about inadequate assignment, which is one of the more technical arguments, but it often very well can be a winner at times. There's a statute of frauds, fees and interest, statute of limitations, fraud and identity theft, whether a person may be collection proof, and some others that come up from time to time. So defense number one, and this we have a caveat now, used to be a winner, and we'll talk about that in a little more detail, but in order to recover from the defendant, the plaintiff must prove that this debt was assigned, that they were assigned the defendant's debt. Again, typically the profiled cases that we represent, it's not original creditor. So it's not Best Buy and our client, it's Best Buy who sold the account to another party. So that's why this generally only applies to debt buyers. There is case law. Clerk Whalen is a clerk that we are in front of often in our court sessions. And so we have provided you in the email that went out just shortly before this presentation. There are some cases there. It's not all the time that there would be a decision coming out of the small claims court. So if you want to go ahead and look at those, it's interesting. But that's essentially, we're saying this particular entity doesn't have the ability to prove that they have the right to collect against our defendant. All right, and so this is sort of an outline of the argument. The slides are a little dense, but there's a lot of information. And this is, again, outlined in the packet information that we've given you. So there's an outline of the argument here. Again, we are always going to make this argument. It's sort of two-pronged, and step number one is always the assignment as we're dealing with debt buyers. And what we're always going to say is the fact here is that the documents provided by the plaintiff, the person who's brought this defendant into court, doesn't prove assignment of his or her, our client's particular account. The plaintiff does have the burden. They've brought this person in to collect against them. They have to prove assignment. It's not the original creditor, and if it was, it would be different, and that is true. And so that's the crux of the argument. It's the assignment part. And then detail how the discovery, and this is Ariel's going to go through this really in depth later on as well, but we want to go through the discovery. The plaintiff has the burden, they've provided us documentation, and now we want to go through how that supports the documentation they've brought in actually supports our argument. So we need to argue that the documentation they've provided, doesn't show the client's exact account. Oftentimes, as Ariel will go through in depth, there's no account numbers. It's very general documentation that is supposed to purport the transfer of these accounts. Maybe there's not a full chain of custody. There's no bill of sale. These are very common issues that we see again and again. And then we'll say to the magistrate, lay it out for them, which Ariel is going to do. We'll walk through each document and detail what the issues are with the particular document. And so next, this is sort of a two-pronged argument, as I mentioned. Number one is assignment, which is saying this particular entity is not able to collect against our client. And then next is about any damaging evidence that they may have. One thing that we're seeing often is a data sheet. So it's going to be something that has been generated likely internally, and they're purporting to argue that this shows evidence that accounts were transferred again. Oftentimes, and we'll go over, some of this has changed a little bit. Oftentimes it's not an affidavit, it's not certified. There's, if anything, even if the document is potentially damaging, we can argue that it shouldn't be given much weight because we can't determine exactly when, why, how that document was made. And so it's always a closing. Again, any argument we're going to make, we're going to say that the plaintiff simply has not provided sufficient evidence. It's their burden. And for that reason alone, judgment should enter for our client, defendant. Dorothy, did you have a question?
No.
Oh, okay.
No,
I apologize. I thought I heard you.
Oh, no. I'm sorry. I thought I was on mute. I apologize. I probably just made some
worries.
weird
I'm sorry.
noise. It's okay.
Apologies. Okay. And so defense number 2. So we're going to try to say that on the merits of the case, that, argument number 1 is always merit of the claim. Plaintiff hasn't met their burden and this matter should be dismissed. We also want to make a backup argument, which is even if the court, we're not going to concede that that's not the determination that should be made, but if the court were to find in the plaintiff's favor, it still has to then award a particular amount of damages. So the notice of claim, statement of claim, that is going to list a particular amount that the plaintiff is seeking from our client. In order to collect fees and interest, which Massachusetts has very high, 12% interest, so it adds up significantly, the plaintiff has to produce a signed contract of the original applicants. And without that, they should not be entitled to interest or fees. That is something we very often don't see, and it can help us mitigate damages that are awarded. So that's something that's very important to be aware of. And then also fairness, again, so there's a more technical argument, but then also just good faith fairness. What we'll often do is look to calculate what has the plaintiff actually proven here. What, are there charges that they've been able to prove through various statements, add up all the charges, and then did the client make payments? Oftentimes in those statements that are produced by the plaintiff, there's going to be payments made on there as well. And so we can then deduct. So we're able to come up with an actual number that is oftentimes much less than what is being sought. We do have a trial preparation chart that's referenced here that REO will be utilizing in practice as well. And then again, we say for all these reasons, judgment should enter for the defendant. So that is sort of minimizing the damages or the amount that should be awarded by the magistrate. Defense number 3, statute of frauds. So this is certainly sort of a technical legal argument. Massachusetts, as well as the Uniform Commercial Code, call it the UCC. What it says is that if a contract is not written out and signed by the party to be charged, then anything over $500 in value cannot be collected. It must be expressed in writing and signed. And so that's what we're going to argue to the court. Because again, they very rarely, if ever, really never have that. Again, this is a debt buyer. This is not the original party. And oftentimes, if anything, REO will go through this, but it's sort of a generic summary of terms, and it's not a document that has been signed by the party. If there's no signed contract produced, then the amount is in dispute at most. Then what the magistrate should award is the $500. And then sometimes you can push that even farther if you have statements proving payments. I would go ahead and argue it should be $500 minus whatever the client has paid. So again, we're arguing there's no business relationship. There's no signed contract. Statute of limitations, another important legal concept to be aware of. Pretty straightforward here. There's only so much time that you can pursue a person to collect a debt against them. Massachusetts is 6 years from the last payment, so there is a little wiggle room there sometimes, but it's 6 years. Delaware, 3 years from the last payment, and the UCC, 4 years from default for the last payment. It is an uphill battle, as REO has mentioned here. We will try to push that back and say that it should be, sometimes there can be a dispute over when the statute of limitations really should have started running, because that may be favorable to our client. As you will see, these cases are often brought to court years later. But unfortunately, in practice, this is very rarely a viable defense. We don't see this as a viable defense too often, but it's good to be aware of it. All right. We do deal with clients who are ultimately, unfortunately, the victim of identity theft. So either somebody else opened a fraudulent account in their name completely, or maybe it was used some of the time without their knowledge. And so this is very common. What we see, unfortunately, is ex-spouse or domestic partner relationships. They've opened an account and made charges sort of unknowingly to the party whose name it was opened in. Other times it's stolen. The identity was stolen. There's a number of accounts that have been opened, or a particular card, a purse, etc., was stolen. So that is, it's not a trial defense necessarily, but it certainly is a defense when we're speaking to the client. What we would do in these circumstances is recommend a fraud affidavit. So we would assist them with completing the necessary paperwork. There doesn't have to be a police report either. Sometimes clients will be weary about that. They're going to say, this is so many years ago. I never filed with the police. That's not necessary. We'll help them complete that paperwork so that that could be completely dismissed and be taken off of their credit. All right, and a very common in practice, this is one of the most common successful defenses that we have, and that is a party is collection proof. Essentially, they have no non-exempt income. All of their income, if any, is exempt. No assets. They cannot be legally required to pay the plaintiff. This is not a defense to judgment. This is really a defense to payment of a judgment. And so what the small claims rules say that a magistrate cannot enforce a judgment which relies upon certain exempt types of income. It's typically government income, veterans benefits, Social Security. And so what we do is when we do an intake with a client, if we determine that they have no income whatsoever, or it's only exempt sources, we will go ahead and fill out a form, a hardship dismissal application that we will then send to the plaintiff's counsel, essentially saying, you should dismiss this. Even there's no incentive here to take this all the way to a judgment. It's not going to be able to be collected on, and we'll ask them to go ahead and dismiss it. We'll oftentimes provide evidence, the Veterans Benefits Award letter, for example, and we have a high success rate with these. For the most part, this is an option that many of our clients can utilize. Okay, here's a list of all the following sources. So again, we will send this to you. It's in the packet. I have it in the front page of my binder here. It's just one important thing to know, those various sources that are exempt. Okay, and then one more thing, accounts stated. This is, again, one of the more technical matters that comes up, and it doesn't come up often, but you should have an idea of what it is every once in a while. The plaintiff's counsel is going to sort of add this in, maybe even at the end of the hearing. So be prepared to hear from the opposing counsel, that they're going to say, well, this is an account stated. Because an account stated is something where both parties, based on transactions, they've essentially acknowledged and accepted this particular account, that there's a balance due. And why this is helpful, or why plaintiff's counsels are trying to make this argument, is because then they don't need to produce the original contract. They're trying to sort of mitigate our assignment argument. But in order to do that, the agreement must amount to, it has to be a recognition of the debt with a promise expressed or applied to pay the debt. Essentially, it has to be the original creditor and the debtor in a contract establishing that this is an account that both parties acknowledge. We go back to the assignment argument in many ways. Here, it's a debt buyer bringing this case. There was no previous signed agreement amongst these two entities that are in court here today. And just, this is not an account stated. That does not apply here. Okay. All right. And so discovery and trial prep. So this is getting into the fun part here. We're going to start practicing in a moment. So of course, you're in court. We've had a client who's indicated they want to speak to us. we've met with them, and now it's time to determine what's best to do. So we're going to meet with them, advise them, consult with them. Of course, you're going to explain yourself exactly what's happening. And you always want to ask what documents they may have. It's not uncommon that they simply may have nothing. And oftentimes what you're going to hear is that the person isn't even really sure who the original, what it's regarding, because they only know the original creditor, not this particular entity that's brought them into court. But it's still helpful, ask them, do they have any debt collection letters, the notice of small claim, which would indicate what was being sought against them. Ask opposing counsel for their evidence as well. Ultimately, what you're going to have to do is review all of the documentation to determine the strength of it, assess it, and determine with your client, really, or advise your client what the best strategy is. It may very well make sense to go ahead and proceed to hearing. Okay. Questions you're going to want to ask your client straight out from the beginning. And as I said, don't be surprised. Many people may not be certain because of the amount of time that's gone by and the number of times the account may have transferred. But you do want to ask, do you have this card? At least if the documentation that's presented by the plaintiff's counsel is likely going to have some of that original information there. Do the charges look correct? Did you authorize these charges? This is, again, sometimes where it becomes apparent that actually this is a fraud matter. Did you sign up for this card? Did you ever receive a letter from the original creditor? And how did you receive those statements? Were they at the address that's listed on these documents? Did you ever live at that address? So getting that background information regarding this particular collection. All right. And so, oh, here we go. That's what I was looking for. Here we go to, getting the discovery documents. So again, COVID times, what we have to do now is we ask plaintiffs to email everything, make sure they send you an all-inclusive, comprehensive email with any documents that they would potentially produce if you're to go to trial. Ask them to send it to the court as well so that the court has it. And that's really the best way to do it these days. Is we've only had a few hearings in COVID times, but they'll send it to us. We're able to review it. They'll send it to the magistrate as well. Of course, if we were in court in person, you would simply go up to the attorney, give them a copy of your appearance, and request to see any documents that they intend to introduce at trial. They would have to provide you a copy. You're going to then review it and assess it with your client as we discussed. And so next year, Ariel is going to take over in a moment to get into sort of the nitty gritty of reviewing documents, and then we'll have some fun arguing about it. You're muted, Ariel.
Thank you.
There we
So
go.
I can't see anybody when I'm sharing my screen, but I just went back to the main one and realized nobody has their videos on. So this is perfect. I wasn't missing any reactions whatsoever. But we're going to go into a more interactive part here. So I am going to ask you to participate. This is going to be an active next half hour of evaluating the documents. If you registered for tonight's training at any time before 3 o'clock today, then you already got a packet of documents that I'm now going to sort of walk us through. And we're actually going to practice identifying what the arguments are. And then Jessica and I are going to put on sort of a mock hearing for you so that you can see it. And if we have any brave souls after that, we're going to have you practice some arguments yourselves. Maybe even some of the ones that are coming up like tomorrow for trial. So let's see. So I'm going to share my screen again, but Jessica, if you can monitor people's screens, and if you all can turn your screens on, I'm going to encourage you to do so that we can ask you some questions and get your feedback here on the actual documents themselves.
And I will monitor and field the chat as well. If anybody has any questions, you can throw them into the chat also.
All right, so I'm going to go ahead and share my screen again. All right. So I'm going to talk just for a second about what types of evidence you might encounter during the hearing itself. So these are all the different types of evidence, and you know, it's not set in stone. So last week or 2 weeks ago, we had one of our first trials since court reopened, and they gave us some new documents we'd never seen before. So sort of this list is ever growing. But these are typically what we see. So oftentimes they have account statements, which is basically the original creditor's statements like you get in the mail from your credit card showing purchases, any payments, fees and interest. Often it shows the client's address. They also often include some affidavits, both it could be from the original creditor entity or it could be from the assignee that basically says, yes, we got these accounts, and yes, we transferred these accounts, but they're very general and they don't have very much information on them, and we don't give them any weight. A bill of sale, which is the sort of heftiest document that they provide, which purports to show the assignment from one entity to the next. And oftentimes there'll be, you know, 2, 3, 4 bills of sale. So this account will be started with one company like Synchrony Bank, and then it gets sold to another company, let's say Crown Asset Management, and then Crown sells it to LVNV Funding, and then LVNV sells it to Midland, and then it's Midland who's actually in court coming against the defendant, which is why we can make sometimes some really good arguments, as Jessica was saying, about assignment of the debt, and that whether it's one chain of custody removed or 4 chain of custody removed, they have to actually prove that they are the legal holder of the debt and that they're entitled to collect on it. So the bill of sale is important. Often attached to that is like a Schedule A or an Exhibit 1 or something like that that shows the actual, it supposedly shows the actual sale that we're talking about here. They are supposed to provide a signed account contract from the consumer that actually shows, you know, where our client agreed to take on this debt. And then they have something that's called a data sheet, which will show you it's like an Excel printout, and that's usually the only piece of information that has anything relating to our client on it in the whole packet. And then the surprise document we got last time, and it's kind of similar to a surprise document we have in a trial that's going on tomorrow, is something called a goodbye letter, which is the one from a couple of weeks ago was literally a letter from one entity to the next, which said, you know, we're selling your debt, you know, it's to the consumer from the original creditor saying, we're selling your debt to this new entity, so Midland Funding, and you'll have to deal with them from now, something like that in a little bit nicer terms. And we think that that document could be a problem for us, but we're sort of figuring out right now on our team, and we'll work with you to figure out like, how do we deal with that? So we're gonna walk through a couple packets now of information. So I'm going to share a different screen here.
Hey, Ariel, while you're looking, can I ask you a question about the goodbye letter? Is the goodbye letter somehow evidence that there was a valid assignment? Is that what that's intended to prove? And if there was an earlier assignment, wouldn't that be still problem? I mean, how do you know what the chain of custody looked like even with that letter?
Yeah, it's a good question, Dorothy. And literally we started trial the last time, and they brought out this letter like after we had sort of done our introductory statements. So we'd never seen it before, and we sort of had to react to it on the fly. I think it is potentially an issue for our assignment argument in that it does purport to show, you know, the transfer from one entity to the other of our client specific debt, which is our argument around assignment, that they don't typically provide that evidence. What I don't think it shows is exactly what you're pointing out here, is like, that's just one snapshot in time, even assuming that letter is valid, that it went out to our client, that it wasn't
Right.
prepared for purposes of litigation, et cetera. All it does is capture one moment. It doesn't say that at this moment, coming into court, that the entity that's there is, you know, the entity that's still entitled to collect the debt, because after that letter was sent, it could have been sold another time, or, you know, something else could have happened to it. So it's not I don't think it's a slam dunk, but I do think that it limits our ability to say what we've said before, which is that they have produced no documentation whatsoever about the transfer of our client's account to this new entity. And in our case, it was particularly potentially damaging. We haven't gotten the verdict back yet, but because it was a one transfer case. So,
Got it. Oh, yeah. A one transfer case makes it harder with that letter for sure.
Yeah.
Okay, thank you.
yeah. So, okay. Good question. All right, so I'm gonna share some discovery with you, and we're gonna walk through what the documents actually look like. So here on my screen, you can see this is a discovery packet that we got. This is actually the trial that we did 2 weeks ago. So this is a very typical packet. So what we have up front is a bunch of statements. Can everybody see this document okay on your screens, or do you have it in front of you? It's called trial example. If you're going to pull it up from the email that Jessica sent around, we're looking at the one that says trial example. And what has been provided here is very, very typical. So basically, they often provide the last statement in time, which is like the charge-off statement, they call it, which is the last one showing the total amount owed by the defendant. And then they also typically show the last payment by the defendant as well. This one is a little more robust because they do provide 5 different statements, but it doesn't really matter. What stuck out to me here is this fees charged of $4.77. So this is pretty typical. You see here, there's a payment of $35. There's interest charge. There's usually, you know, payments, fees, and interest in most statements. And then here, there's this extra like $4 charge, which I thought was really interesting. And when you look at it here on the middle of the statement, you can see that it was a debt protection charge, ironically, that our client was paying $4 a month for some sort of debt protection service. And it's important to ask your clients if they signed up for that, because sometimes these get like snuck in to clients' arrangements with credit card companies. They don't even know that they're paying for it. So in this case, our client said, yes, I did agree to pay that. And so we didn't really worry about it, but that's one of the things that you'd want to check out. So you can see here, it has the transactions listed, very basic credit card statement at the end of this month, which was April of 2018. You know, the balance due at that time was somewhere around $515. All right, so it's just very typical credit card statements. They, like I said, they usually only have 2, the first and the last. What was interesting to us in this case, which you can see if you go through it, is that on each statement, our client made a payment. So here now, the next statement is from July 2018. You can see our client made a payment of $27 there, and there's no charges to kind of increase the balance. Also that $4 fee again. The next statement, you can see that our client made a payment of $40. So at some point I started saying to the client, gosh, it looks like you've been making a lot of payments on this. This is going to really help us out in terms of our arguments about how much you actually owe. Even assuming that they buy the assignment argument, we still are going to, you know, ask them in fairness to reduce it by the amount that we can show that you actually paid on it. So in this one, which is the March 20th statement, you can see, okay, here's one charge. So one charge in the amount of about $162, followed by, again, another payment in the amount of $40. Okay, nothing really interesting on the statements. We get to the next one, again, a payment of $30. No further charges, just fees and interest. And then Next statement, another $30 payment. So these, okay, then we get to this page. So on page 31, so the whole first 30 pages are just account statements. On page 31, this is a credit card agreement. And you'll see, I mean, it looks really odd here to me. I don't know if this is like a typed copy, a Word copy. It definitely doesn't have my client's name on it, as if it's some sort of, you know, somehow tied to my client. And what I like to do with these is always look at the date on it. So what you can see here, and what was interesting to me, is that this has a date of 2018. In this case, Citibank was the original entity, and it got sold to, I can't remember off the top of my head. Jessica will chime in and let me know. But that happened, you know, she signed up for her card in something like 2015, and here is a contract dated 2018. So to me, this signifies that this could not possibly be the contract that our client agreed to, right, when she took out the debt. So, and this is often the case, that they don't provide the sort of original contract, which is what's required with our client's sort of signature on it. They certainly haven't done that here. Meaning
Real,
also,
if they prove a sign, so if it was assigned and there was a later date on a contract, would that matter? Can you, in other words, or does it always have to be the original? It has to be the original contract that's assigned, so that we, in theory, if this had been assigned, we'd see something with that 2015 date instead. Is that what we would be looking for?
can you say that again, Dorothy?
Yeah, I'm just trying to figure out, like, so let's say the contract was opened in 2015 and there had been 2 assignments in between, and now we're dealing with a newer, you know, a statement from 2018 with a different bank. So they may have a newer contract attached to the newer statement with their bank. And so I'm just trying to figure out, if there was an actual lawful assignment, would we have to be seeing the original contract, or would we be seeing a new contract that was attached to the new bank's statements?
Right. No, so they don't take out a new contract with the debt buyer.
Okay, okay,
That's the original contract that
Okay.
passes from entity to
Got it.
entity. Good question. So this page right here is the data sheet, and it almost always looks like this. Sometimes it looks like an Excel that's like on its side and it's much smaller, but you can see here that even on this document, sometimes it's redacted just like this when we get it, and it's like, okay, well, you're not really providing us with anything. But typically this is the only piece of paper that they have that shows anything related to our client. And the problem is that this is just like a piece of paper. This is, we don't know like who typed this document, where it came from. It's not verified. It's not sworn to. Like, this could be anything from anybody. So we try to tell the court, like, this should be no weight. This right here is the bill of sale, which we talked about, which is the heavy hitter document, usually, which purports to show from one entity to the next the transfer of assets. But it's not sufficient. And typically it'll say something like this, which for this one, it says that there was a master purchase and sale agreement dated February 16, 2018 between the buyer and the bank. And that there was also an addendum at a later date. And one of the problems here for me in this case was they didn't provide those documents. So they didn't have a copy of the agreement and they didn't have a copy of the addendum. So, you know, they transferred something maybe, but it doesn't say what. And then the other thing is that they always say something like this, which is, you know, the accounts that were sold are summarized on the attached, they'll say here, Exhibit A or Exhibit 1 or something like that. Okay, well then usually you go to the next page. And does anybody see here what the issue is? Let's go back to this one. So it says here, blah, blah, blah. The asset schedule is in Exhibit A. So then I get to this page. Who sees what the issue is with this document?
And that's what it looked like when we received it.
Yeah, redacted like this. But beyond the redaction, can anybody see like an immediate issue? And I
You
can't
have
see
no
any
idea who it belongs to.
Okay, we have no idea what it belongs to.
Well, it's not
Exhibit
Exhibit A.
1? Exhibit 1.
Dorothy, exactly correct. It's not Exhibit A.
It's not Exhibit A. So they said up here, what we sold, the accounts were in Exhibit A, but you get to this page, this is Exhibit 1. So how do we know if this is even the right fresh flow sale? I mean, who knows? There's nothing here. And even if this is the right transfer, there's nothing here that lists our client's account.
Right. I mean,
No.
how can you possibly know what accounts are if it's sold in a lot?
Right.
Right. So what we argue that we need is, you know, they certainly could prove this document. They could do it. They just don't do it. If they had something listing, you know, our client's account on this date in this batch of sales, it would be so different, but this is all they provide and it's not sufficient. It's just not sufficient. And that's how we win on assignment, is that they just don't, they could theoretically, but they do not produce the level of specificity that we need to link this to our client.
Right. No, and that's a good
Are
to
you-
almost just take a quick step back to put this into perspective. That's essentially it, is that we're dealing with, there was an original creditor. They've sold this, and oftentimes it's a bundle of accounts. So it's a number, you know, thousands maybe of accounts again and again. So that's what makes their particular burden very hard to prove.
Are they
Right.
still doing are you guys still seeing them like, you know, doing sales back and forth and then splitting groups and stuff like that? Or is it more tame generally?
Yeah, I mean, as we talked about in our basics training, we really haven't been doing trials very much at all. So we haven't been seeing the documentation, Patrice, to know that, you know, it used to be that we would get a bill of sale that like 4 bills of sale, you know, one company to the next, to the next, to the next. We don't know. We've only had 2 so far. And we sent you both the discovery packets that we've gotten. And this one is much more robust in terms of what they provided, still not sufficient. And the other one, all they provided was 2 documents, like 2 statements and 1 letter, and that's it. So we gave you some examples of what they look like at the current moment.
I have a
Gonna be
question.
fun.
So why is the last one, the last document 44 from Citibank, why is that not sufficient for them to prove that it was her debt that was sold?
Great question, Stephanie. And that is what we were talking about before about the goodbye letter. So
That's
this
the
is
new
the
document. Yeah.
Can you put that up on the screen for us to see?
Yeah.
I mean, it's a little self-serving, isn't it? That letter?
Yeah, it's self-serving. And like I said, Stephanie, like this is a snapshot in time. So even if, so this is a letter, I'm sorry it's so heavily redacted. We'll send you over, you know, a more clean one. But basically it says, "Dear consumer, your loan with us has been sold to this new entity and is no longer owned by us. Here's the balance. Effective immediately, your correspondence will go to them." And that's basically it. So yes, so as I said earlier, Stephanie, this is, we think, a little bit damaging to the assignment argument in that it does sort of purport to show what we say that they haven't yet, which is a transfer of our client's specific account. And in this case, it's a one transfer case. So it's sort of like, okay, but we still have the defense arguments, which I'm going to sort of model for you right now, of like fees and interest and the defense of statute of frauds and a whole bunch of other things to show that, like, okay, even if you buy assignment in this case, because it's a one transfer case, there are still defenses that we can make for this client. And I'm not sure that I think that this one letter on April 5th, 2019, you know, shows.
I mean, how relaxed are we talking about in terms of evidentiary rules? I mean, that's pretty relaxed. So I can type a letter tomorrow to Jessica and tell her that I've transferred her loan, but if I haven't a bill of sale or something that actually demonstrates that I did it, that is kind of a relaxed rule. I mean,
No, that's exactly correct. And that's why that's one of the arguments we try to make. Also, what the weight that should be given to it.
Yeah.
We just recently, for the first time, saw this same type of goodbye letter, but it was also notarized. It was a keeper of the records. And
Yeah.
so that,
yeah, that
and it was
seems
a
better.
single transfer case. And so
Yeah.
that is a more significant issue, I
Yeah,
think,
yeah.
for us to deal with.
Yeah,
Yeah.
yep, I'd agree with that.
All right, so we're running a little short on time. We wanted to both kind of model a sample for you so you could like hear what an argument sounds like, and then also give you a chance to practice. We're probably not going to get to both of those. So what would be the most helpful for folks that are on the screen? And we'll certainly do a follow-up too. And Jessica and I are always happy to practice with folks individually. Would it be helpful for me to go through and do sort of a mock argument now so you can hear it and see it? Or
Oh,
would
yeah,
you
we
like,
have one chat. Yeah, we have a couple that say model and a couple that say breakout rooms, but it looks like a model. I think seeing you do it probably is going to help put it all into context.
okay.
And the good news is the plaintiff, I could be the plaintiff, and that takes about 2 seconds, right? All right.
Yeah, and I think actually we'll probably just skip and do.
Yeah, you know, they basically just say, you know, she's here, she owes us money, and then they give the documents to the clerk. So
Yeah, so I'm actually gonna share then, we sent around to you, it's called like the walkthrough trial guide. And we will send this document to you before every court session so that you have it. And this is really a guide to you so that you can literally walk through a hearing. You know, it kind of has every argument here prepared for you. And what I do is basically what we just did, which is walk through the discovery. In this case, that was all the discovery that they provided. And in fact, I didn't even have the goodbye letter when I was prepping for trial because they literally handed it over after we said that we were starting trial. So sometimes you have to adapt your arguments on the fly. But basically this tells you, okay, here's what the process is. You're going to turn in your LAR form to the magistrate, which right now is electronic, but typically you would hand it up. Then it shows that the plaintiff is going to submit certain documents. So they basically take this packet and they hand it up. They might ask your client a couple questions like whether they still live at that address, whether they opened this card, whether they made payments, but not like literally like 3 questions. Then we have the opportunity to question our clients. So we sometimes ask them like, before today, had you ever heard of this entity before? The point being that they didn't take out the debt with whoever the debt buyer is, but they did take it out with the original creditor. And then after that, we start our argument. So literally the question, the submission of discovery on the question part takes maybe 5 minutes at most, usually like 2 minutes. This is really quick. So then what we do is I like to, when I go through the discovery, I just sort of type in, I fill in this document with like what's applicable to my exact client. So here, I'm just going to read you a little bit of like what I prepared for this particular case. And we usually only have about, 5 or 15 minutes to prep it. So that's why it's all kind of written out for you here and you just fill in the facts. So
Ariel, can I ask you a question before you go into this? So if I show up on a Friday, lawyer for the day at the court, I'm not going to, this doesn't happen on that day, right? Because we get there for the first time, we don't have the plaintiff's documents. And since we're not physically in court, can we receive the documents same day, same session, have enough time to actually be ready to do what you're doing right now? Or
no, we do it, Dorothy, day of. So typically
okay.
when we're in person, they hand us over the documents. We have time to look at it. We prep our client right there on the spot, and then we go to trial that day.
That's in person, but what about virtual?
Well, virtual, we've tried to push now both cases to go that day. So the last one that we did it that day. So we got them to email the documents.
Right, to
Okay.
email it to us.
With our client, and we went to trial that day.
Even though it can feel a little fast, one, that's why we want to give you the tools to be prepared. And also oftentimes it's in the client's interest. They really want to get this taken care of. They want to have it addressed, and the court will kick it out another 3 months or so. Meanwhile, interest is accruing.
Okay, got it.
So I think what we'll do is I'll do, a 4-minute argument here, and then we have an idea about how we'll be able to practice with you guys. So So it's important that you kind of treat this formally. And so I always start on the record by introducing myself, even though it's kind of obvious and we've started, but I want the record to really reflect like a solid legal argument for my client. And typically they go first, but sometimes we go first. So I always start out, good afternoon, whoever the magistrate is, like Clerk Whalen. My name is Ariel and I represent Miss McKnight, that's a changed name, by the way, the defendant in this case. There are several issues with the plaintiff's case that I want to address today and which dictate that judgment should enter for my client in this matter. So first, I want to talk about inadequate assignment. As in many other debt cases, the major problem here is the fact that the documents provided to you today by the plaintiff do not prove the assignment of my client's specific account. As you, the court, know, the plaintiff has the sole burden of proving assignment, and that they are the entity legally entitled to collect this debt from my client. It's important to note that it's not Citibank, the original creditor here today. If it was, this would be a different kind of case. Instead, in order to prove assignment, the plaintiff has to produce proof that it acquired my client's exact account. This includes a full chain of custody from the original creditor to the plaintiff. And then what we have, and then you jump to like telling them about the evidence. So I would say like what we have here is a single bill of sale purporting to show a transfer of a general pool of accounts. None of the documents provided specifically reference Miss McKnight or that she was part of that pool. So if you look at the documents, what we see is that, and I would say like turn to page 50, bill of sale. So we know that Citibank transferred something perhaps on this date to Midland Credit Management via a purchase and sale agreement that was dated February 16 and an addendum on March 8, 2018. But we have not been provided, and the court has not been provided with either of these documents. So we cannot, and more importantly, the court cannot ascertain exactly what was contained in the transfer. And I would say furthermore, the set of accounts that were supposedly transferred are listed according to the bill of sale in Exhibit A. However, if we turn to the next page, we can see that there's a fatal error here, which is that exhibit is titled Exhibit 1, and there's no indication that this document in any way relates to the prior document. And in fact, I would argue it cannot be the same list of accounts that the bill of sale lists as Exhibit A. So the only document, so then you need to attack if they have any good documents. So then I would move on to attacking the goodbye letter and the data sheet. We always mention the data sheet because that typically is the only document that mentions our client. So I would say something like, it's important to talk about the data sheet that has been provided. However, this is not account level documentation, which is required. The plaintiff has not introduced any testimony about this piece of paper or evidence about it. Don't know how it was created, who created it, whether it was created just for purposes of today's litigation or any other means of verifying information shown. And accordingly, the data sheet should be given no weight whatsoever. So quite simply, the plaintiff has not produced sufficient evidence to demonstrate adequate assignment. And for that reason alone, judgment should enter for my client. So that's like the first argument. And then I often stop and I say, I have more argument for the court about fees and interest and if necessary, right? So they might say, you know what, I've heard enough. I can make my decision now. Or they might say, yeah, let me hear the fees and interest argument. So I sometimes pause there because if you don't need to go on because you've already won the case, then I don't go on. But if I do go on, then I do what Jessica had talked about before, which is sort of a fairness argument, which is that they could have come in and provided all of the documents that to show like all the charges on the account, all the information, and they didn't. So they're limited to just what they proved here today, which we went through and we added up exactly what they sorry, that's not the right document.
Went through the statements and added up all of the charges that the statements proved, and then deducted all of the payments that she made. If you remember, the balances really kept going down.
So, right. So in our client's case, we made this handy little chart that day to show that actually she made $162 worth of payments. And the only charge that they had shown on it was $161.49. So really, they owed our client 51 cents plus at most the $22.92 of fees charges that our client admitted to signing up for. So in this case, our argument was that at most, the most amount that you can charge our client if you find assignment and if you believe the plaintiff has proven it is $22. And really, it should be a zero-sum game, and you should award favor in favor of our client. So there's a number of further things, but I want to be sensitive to time. And I think what we're going to do is we're going to offer a third training. So now that we've kind of walked through this piece of it and you've kind of seen a little bit of the modeling and you have the documents in front of you, we're going to plan a third training where it'll just be practice. So it'll be an opportunity for you to take these documents. We're prepping up 2 different cases. At that time, we'll know how tomorrow's trial goes. So we'll be able to bring in some insights from that. And we'll just give you a whole session where we'll just practice in breakout rooms individually. Does that sound good to folks?
Yeah, that sounds good.
Okay, and I'm happy to stick around. I know it's 6 o'clock now. I'm happy to stick around and answer any questions that folks have now, but if you need to head out because it is 6 o'clock, please feel free.
Yeah, Ariel, I do need to head out. It's Dorothy, but thank you both, Jessica and Ariel. It's great training. I'm nervous, but I signed up for 2 already, gang. So who's ever on from Mass Mutual, sign up. Let's do it. We can do it.
Where do we sign up?
Yep, good question. So we have a sign up Genius link. It's hyperlinked in the PowerPoint that we'll send out to you, and also we'll just provide a simple link to it as well to all the registrants of this. But yeah, just click on the sign up Genius link. Join us any Friday. We're not going to throw you in to anything that you're uncomfortable with or that you're not prepared for. You know, we will, as we said in the basics training, you know, we'll match you with somebody who's experienced. We'll give you a chance to observe. You're not going to be asked to do anything that you're not comfortable with or that we don't feel, you know, is right. But we are pretty confident that you've now been sufficiently trained and you should come join us. And once you are in court with us a couple times, you're going to want to jump in and participate.
And you may even be able to observe a hearing. You know, you could go to volunteer and just sort of watch and maybe even see a hearing or 2. But now that we've gotten you some discovery documents, we certainly could have a third training and we'll really just have you argue it. You know, part of the practice is reviewing the documents and getting comfortable with what you're looking at. But we're very happy to join.
If anybody at Mass Mutual wants to do like a buddy thing, just write to me and we'll figure that out.
That'd be me, Dorothy.
Just write to me. Write to me. We'll set people up with buddies for sure. Okay.
Perfect.
All right. Bye, everybody.
I had a question about possibly observing. I had emailed, I think Ariel and Jessica, I think I emailed you both. I do want to observe because I set up my, like actually doing it towards the end of the month, but me and my friends, we were wondering if we could observe first.
Yeah.
So how do we go about that? Because I know there's no option to observe online on the link that you guys sent.
Yeah, no, you can, I'm sorry, Ariel, I'll just jump in. You can just sign up as a volunteer and it will be myself or possibly Ariel who would be assigning in court. So I'll know that you're a new person. Any new person, we're typically putting you with a more seasoned volunteer. So any first time volunteer, maybe even a second or third time volunteer, you're not going to have a client immediately. You're going to observe other folks first. That's pretty much standard practice. Yeah.
Okay, perfect. Yeah. Thank you so much.
Yeah, no, absolutely. And just very quickly, we often will even have a quick phone call ahead of time and check in with folks to see what their comfort level is. Some people have done something like this before. So yeah, you won't just get thrown in where you don't want to be.
Okay. All right. Perfect. Okay. That is definitely great to hear. Thank you so much.
All right. Thank you.
All right. Thanks everyone so much for being here.